So you've decided to represent yourself in a Florida divorce or custody case. First of all, respect. Second of all, you should know that the Florida court system has an almost impressive number of forms, rules, and deadlines, and exactly 0 of them will be handed to you with a helpful explanation. Well, that's what this video is. I'm walking you through the entire procedural life cycle of a Florida family law case, from the petition all the way through trial. We're talking Florida Family Law Rules of Procedure, Chapter 61 of the Florida Statutes, Florida Supreme Court approved forms, the whole deal. Now, before we get started, I want to introduce myself. My name is Sarah, and I'm a practicing family law attorney in Florida. My goal for this video is to provide anyone who may be going through a divorce or custody case with the basic information needed so that you have a clear path to what you need to do. One quick disclaimer, even within Florida, some procedures vary by circuit. So the 13th Judicial Circuit runs a little differently than the 4th. So while the rules of procedure apply statewide, always check your specific county's local administrative orders and self-help center. Most Florida courthouses have one. So this is just a quick overview. If you want a real deep dive companion to this video, then be on the lookout for more being posted to my channel. Okay, let's get into it. Before you touch a single form, there's a threshold question. Does Florida have jurisdiction over your case? Under section 61.021 of the Florida statutes, at least one of the parties must have been a Florida resident for at least 6 months before the petition is filed. That's the baseline for a dissolution of marriage. You can prove residency with a valid Florida driver's license, or even have someone you know sign an affidavit stating how long they've known you and how long you've lived here. Now, active duty military members stationed in Florida get some leeway here under section 47.081. So if that applies to you, look into it. For a custody only case, meaning you were never married, the rules are governed by the Uniform Child Custody Jurisdiction and Enforcement Act, or as we like to call it, the UCCJEA, which is a whole other topic. Short version, Florida generally needs to be the child's home state, meaning the child has lived here for at least 6 months. Residency is good? Great. Let's file. Every Florida family law case starts with a petition. The Florida Supreme Court has approved specific forms for this, which is actually great news for pro se litigants because you don't have to draft something from scratch. Here's the menu. If you have minor or dependent children, you're filing a petition for dissolution of marriage with dependent or minor children. Now, that's Florida Supreme Court approved family law form 12.901B1. If there are no minor children and no issues with the dependent child, you use form 12.901B2, petition for dissolution of marriage with no dependent or minor children. If you and your spouse agree on everything and there are no minor children, you may qualify for a simplified dissolution of marriage using form 12.901A, which has a shorter, faster process, but there are specific additional requirements. And if this is a paternity, custody only case, never married, you're looking at form 12.983A, petition to determine paternity and for related relief. Along with the petition, you'll file a few companion documents. You'll need a cover sheet for family court cases, which is form 12.928. It helps the clerk categorize and track your case. There's also form 12.900H if any related cases exist. A civil indigent status application if you can't afford the filing fee. Ask the clerk because filing fees in Florida can run a few $100s and the waiver process is real. If children are involved, a proposed parenting plan, which is form 12.995A or 12.995B if safety concerns are a factor, or 12.995C for long distance situations. And the UCCJEA affidavit, form 12.902D, which tells the court where the children have lived for the past 5 years. It's required anytime minor children are involved. You're going to file all of this with the clerk of the court in the county where you and your spouses lived for the last 6 months. If your case involves minor children, and this includes paternity cases, Florida requires both parties to complete a parent education and family stabilization course before the court can enter a final judgment. This is section 61.21 Florida statutes, and it's not optional. However, the court may excuse a party from attending the parenting course or from completing the course within the required time frame for good cause. The petitioner must complete the course within 45 days of filing the petition, and the respondent, the person who was served, must complete it within 45 days of being served. You file proof of completion with the clerk. It's a 4-hour minimum course, and most are available online. You have the ability to take the course in one sitting, or you can take it in piecemeal and break it up. What matters is you take it, pay attention, complete the quiz at the end, and file your completion certificate with the court. The court can actually hold you in contempt for failing to complete it or sanction your timesharing rights, so just take the course. Once your petition is filed, you have to officially notify the other party legally. This is called service of process, and in Florida, it's governed by the Florida Rules of Civil Procedure, which apply here through the Family Law Rules of Procedure. The standard method is personal service by a sheriff's deputy or a certified process server. They physically hand the documents to the respondent. Once served, the respondent has 20 days to file a written response. Make sure the certificate of service is filed with the court. If you can't locate the other party after a good faith search, Florida follows constructive service, which is basically publishing a notice. But here's the catch. If constructive service is used, the court's power is limited. The judge can dissolve the marriage itself, but generally cannot award child support or alimony without personal jurisdiction over the other party. So constructive service has real consequences. For that process, see Form 12.913A2, Notice of Action for Family Cases with Minor Children, and Form 12.913C, the Affidavit of Diligent Search and Inquiry. One more thing. If the respondent is cooperative, they can sign a waiver of service of acceptance of service. That sidesteps the whole process server situation entirely, and it saves everyone time and money, which is important. After being served, the respondent has 20 days to file their answer, responding to each allegation in the petition. If they want to ask for something themselves, like their own requests for property, support, or custody, they can also file a counter petition using the same form series as the original petition. If the respondent blows the deadline and doesn't respond, well, the petitioner can file a motion for default, which is Form 12.922A. Now, a default doesn't automatically mean you get everything you ask for in a family law case, but it can allow the case to move forward without the other side's participation, which is obviously not a great position to be in if you're the one who forgot to respond. Once both sides are in, it's time for the part of this process that makes people want to move to a cabin with no mail service: financial disclosure. Rule 12.285 of the Family Law Rules of Procedure, remember that number, creates automatic mandatory financial disclosure in virtually every Florida family law case. Both parties, no exceptions. Unless the court orders otherwise or both parties mutually agree to waive certain filing requirements, you are doing this. Here's what each party must serve on the other within 45 days of service of the initial petition. First, a family law financial affidavit. This is a sworn detailed statement of your income, expenses, assets, and debts. Now, Florida has two versions. If your gross annual income is under $50,000, Form 12.902B, the short form, is for you. If your gross annual income is $50,000 or more, Form 12.902C, the long form, is for you. The affidavit also has to be filed with the court. Along with the affidavit, you must also exchange the last 3 years of complete federal and state personal income tax returns, pay stubs, bank, investment, and retirement account statements from the past 12 months, documentation of all real property owned, deeds, mortgage statements, any business records if you're self-employed, profit loss statements, ledgers. For a more detailed list, please review Florida Family Law Rules of Procedure 12.285. Once you've exchanged all of this, you file a certificate of compliance with mandatory disclosure That's Form 12.932, which identifies what you produced and when, and you swear under oath that your disclosure is complete and accurate. Why does that matter? Well, because this financial snapshot is the foundation for everything. Child support calculations under the Child Support Guidelines, which is Form 12.902E, alimony determinations, and equitable distribution of assets and debts under Section 61.075. And yes, since this is all under oath, if you hide assets, underreport income, or forget to mention that vacation home, that's perjury. It also tends to make judges very cranky, and credibility at trial is something you really can't afford to lose. Mandatory disclosure gives everyone the baseline financial picture, but what if you think the other side is hiding something? Or what if you need more specific information? Text messages, business records, the other parent's work schedule, documentation of an asset, maybe? That's where discovery comes in. Florida family law discovery is governed by Rule 12.280, which incorporates the Florida Rules of Civil Procedure, meaning many of the same discovery tools used in any civil case are available to you here. So let's go through the main ones. First, we've got your standard family law interrogatories, and Florida has a set of approved interrogatories specifically for family law cases. That's going to be Form 12.930B. These are pre-written questions about income, assets, debts, parenting, and you can use them as is, or in some circuits, you can supplement them with additional questions. The other party is going to have 30 days to answer in writing under oath. Next, we can look at requests for production of documents. Now, under the Florida Family Law Rules of Procedure 12.350, you can ask the other party to produce specific documents. More bank records, emails, text messages, business records, photos. You define what you want, and they also have 30 days to respond. Request for admissions. You serve a list of statements, and the other party has to admit or deny each one under oath. Great for pinning down facts that shouldn't be in dispute. Ownership of a specific account, an address, the date of a transaction. Very helpful discovery tool. Depositions. This is testimony under oath taken before a court reporter outside of court. Either party or any relevant witness can be deposed, and it's recorded, it's transcribed, and if their story at trial contradicts what they said at deposition, you can use that against them. Depositions are powerful, but they also cost money. You're typically paying for the court reporter and the transcript. Third-party subpoenas. You can subpoena records directly from banks, employers, insurance companies, the Department of Revenue, even social media platforms in some cases. Under Florida law, you serve a subpoena on the third party and notify the other side. Now, here's a critical warning for pro se litigants. Discovery has strict formatting requirements and hard deadlines. If the other side sends you valid discovery and you ignore it, Rule 12.380 allows the court to compel your response, impose sanctions, or in extreme cases, draw adverse inferences, meaning the court may assume the worst about whatever you refuse to produce. Don't ignore discovery. If you need help with formatting, your county self-help center is your friend. Here's something a lot of people don't realize while all of that discovery is happening. The case can take months. And during those months, real life doesn't pause. Kids need stability, bills need to be paid. Someone might still be living in the house when the other one doesn't want them there. That's where motions for temporary relief come in. Florida has a specific form for this, which is Form 12.947A, Motion for Temporary Support, Timesharing, and Other Relief with Dependent or Minor Children. Form 12.947C if there are no minor children. You can ask the court for temporary orders covering temporary child support, which is calculated using Florida's Child Support Guidelines. Temporary timesharing, which is a schedule for the kids while the case is pending. Temporary alimony or spousal support. Temporary exclusive use of the marital home, basically who stays, who goes. Temporary responsibility for specific debts, like the mortgage or car payments. Temporary attorney's fees if there's a significant income disparity. Important. Rule 12.285C has separate accelerated disclosure requirements for temporary financial hearings. If the hearing is within 45 days of service of the initial pleading, the moving party must serve the required financial documents along with the notice of hearing. At the hearing, outcomes can include the judge granting your request as filed, denying it, modifying the terms, or entering a hybrid order. Whatever the judge orders is temporary. It holds things together until the final judgment, but it is impermanent. And yes, if someone violates a temporary order, contempt is already on the table, which leads us to a quick detour. If a party isn't complying with a court order, whether it's temporary or final, you file a motion for civil contempt and enforcement under Rule 12.615 of the Florida Family Law Rules of Procedure using Form 12.960. The motion has to spell out exactly what the other party was ordered to do and exactly what they didn't do. You then serve it along with a notice of hearing, which is Form 12.961. And here's the language that notice is legally required to include if the violation relates to a support matter. Failure to appear at the hearing may result in the court issuing a writ of bodily attachment for your arrest. If you're arrested, you may be held in jail up to 48 hours before a hearing is held. No, that's not a threat. That's statutory notice. Florida courts take court order compliance seriously. Possible outcomes at a contempt hearing. The judge finds no contempt. The other party showed inability to comply or a valid reason. The judge finds contempt and orders compliance with a purge condition, which could say, pay the arrears by this date or you're in contempt. Attorney's fees and costs awarded to the moving party. Coercive fines. In serious or willful cases, incarceration as a coercive measure until compliance. Now, something to keep in mind, this is civil contempt, not criminal. And the idea is to compel compliance, not punish, but it has teeth. Under Rule 12.740 of the Florida Family Law Rules of Procedure, all contested family matters may be referred to mediation. And in most Florida circuits, standing administrative orders make this automatic. You're going to mediation, plan on it. Here's how it works. The parties, with or without attorneys, meet with a Florida Supreme Court certified family mediator. The mediator doesn't decide anything. They facilitate communication and help the parties reach their own agreement. Everything discussed in mediation is confidential and generally cannot be used as evidence if the case goes to trial. That's by statute. So your mediation can end in one of three ways. You can either come to a full agreement, and that then gets filed with the court. The judge reviews it, and if it's legally sound and in the children's best interests, signs off. Case is essentially over once the court signs a final judgment, incorporating and enforcing your agreement. You can also end up with a partial agreement, which means you agreed on some issues and not all of them. The agreed portions get locked in, only the remaining disputes move forward to a trial. This is actually really common, and it's worth noting that narrowing the issues can significantly shorten and cheapen a trial. Now, what happens if there's no agreement? Well, that's called an impasse, and the mediator is going to file a report with the court indicating that mediation was unsuccessful and the case is certified for trial. If mediation didn't fully resolve things, the court will set a pretrial conference. The judge checks in on the status of the case, confirms or sets the trial date, and typically requires both sides to file a pretrial statement or pretrial stipulation, which is essentially a roadmap listing unresolved issues, witnesses, exhibits, legal positions, and any agreed facts. A few other things often happen around this time. The court may issue a pretrial order setting specific filing deadlines for exhibit lists and witness lists. Some circuits require a joint pretrial statement where both sides have to agree on certain background facts. This is also a natural final checkpoint for settlement. Attorneys often joke that more cases settle in the hallway in the morning of trial than any other point. It's funny, but it's true. Florida family law trials are bench trials, which means there's no jury. Just you, the other party, and the judge. Here's the basic structure for how the trial is going to go. You've got opening statements. It's a brief preview of your case. It's optional in some courtrooms, especially shorter trials, but follow the judge's instructions. Then you've got the petitioner's case in chief. The party who filed first calls witnesses, including yourself. You introduce exhibits. The other side cross-examines. Florida Evidence Code Chapter 90 applies, which means rules about what's admissible. Hearsay, authentication of documents, foundation for financial records. Respondent's case in chief is up next. It's the same process, but in reverse. There's time for rebuttal, which means if someone needs to respond to something that was an issue that was raised prior. Then you have closing arguments. Each side summarizes why the evidence supports ruling in their favor. The judge then either rules immediately from the bench or takes the matter under advisement and issues a written final judgment of dissolution of marriage later, sometimes days, sometimes weeks. I've waited for a final judgment for 6 months before, so just be patient. That document's supposed to cover the dissolution itself, equitable distribution, assets, liabilities, alimony if it's awarded, a final parenting plan, and child support order. Once signed and filed, the final judgment is officially the end of your case. But, and this matters, court orders only work if people actually follow them, which brings us back to contempt, modifications, and ongoing joy of co-parenting with someone you divorced. But that's a video for another day. Well, that's the full Florida family law case roadmap, petition to judgment. You now know more about how this process works than a solid percentage of people who are currently sitting in it. Thank you so much for watching. Please hit subscribe, leave a comment if you found this helpful, and I'll see you in the next one.